Hi students, Professor Orenberg here, and welcome to our series on organizational choices. This will be a series of videos covering which type of business association to form and why. And we're going to break this apart into a series of smaller videos to make it a little easier to remember all of the details that are involved in the study of business associations' organizational choices. So let's get started. This series is going to proceed with 6 videos. First, we're going to introduce the process of selecting a business entity by reviewing 7 issues that are going to come up time and time again when deciding what entity to choose. We're then going to discuss the 4 major types of organizational choices: general partnerships, limited partnerships, C corporations, and limited liability companies in the context of those 7 issues, forming a matrix of effectively 4 entity choices by 7 issues. And then in our 6th video, we're going to summarize everything by briefly noting some alternative organizational choices that can be used for professional groups, and then summarizing the 7 issues across this matrix of 4 types of organizational choices. And in that process, you will learn the differences between the 4 major organizational choices and when to select one or the other for basic business planning purposes. Limited partnerships are a classic investment vehicle, and they're built on the principle that certain organizations benefit from vastly unequal roles. Maybe not as unequal as Arnold Schwarzenegger and Danny DeVito here, but the idea with this picture is to emphasize with LPs, with limited partnerships, that we're going to emphasize a strong central management and very passive outside shareholders or investors that are going to participate in a very perfunctory manner, usually just by contributing money. And the general partner is going to be making the investment decisions for this entity choice. So again, the characteristic of a limited partnership is greatly unequal structure by design. Why should we use an LP? Well, why would a person want to give up their rights? Because they don't want other shareholders to have significant control. They only want the general partner who they trust with their money to be managing it. Limited partners generally want to invest money and don't want to be active in management. Otherwise, they would simply invest it themselves. So they're going to, one, want to be involved in the structure because by design, the general partner at the center is the one who they want to have control anyway. They don't want the other investors playing with their money. Second, limited partnerships have a benefit over general partnerships. The limited partners get limited liability. Limited liability means that the general partners cannot lose more than they have invested in the business. And that's important because if you run an investment fund with billions of dollars in it, you don't want to lose all that money because you've made an investment in a company that you don't control, which happens to do something nefarious. The purpose of this is to coordinate between people that have money and people that have skills. So it secures the skills and cooperation of those general partners who have the ability and integrity to manage money, but don't have the funds to make these massive investments. Whereas the peripheral LPs have a great deal of money, but don't necessarily have the ability or connections to make the investments themselves. So again, LPs, think of them as an investment vehicle where the general partner sitting at the center is the one making the decisions, and the LPs on the periphery are going to be investing the money. Unlike general partnerships, the law of limited partnerships is somewhat more confusing. There have been a series of attempts to make uniform the Limited Partnership Act. They haven't been as successful, as you can see from the chart here. There's a variety of different statutes. So we had the original Uniform Limited Partnership Act in 1916, which is still now called the Uniform Limited Partnership Act, or ULPA, ULPA. In 1976, a revision titled the Revised Uniform Limited Partnership Act, which confusingly is now also called the Uniform Limited Partnership Act, was then promulgated, sometimes called ROLPA or sometimes just OLPA of 1976. In 1985, yet another edition came out, now also sometimes called OLPA or ROLPA. 2001, another edition came out, which was ironically called ROLPA, meaning the revised Uniform Limited Partnership Act, and again was officially named the Uniform Limited Partnership Act, this time of 2001. So there's been a lot of uniform acts which aren't the same. In most places, you're going to see it referred to as the act with the year to clarify this. So you'll see ULPA, Uniform Limited Partnership Act, dash 1916 or dash 2001. And in any event, the 2001 Act appears to be the most recent, which has been adopted by a number of states. And that said, not all the states have adopted this, so it's far less uniform in terms of its status as a law. Forming a limited partnership is a bit different than forming a general partnership because it does require a filing with the Secretary of State of the state of formation. This has the benefit of making it impossible to create a limited partnership by mistake. One has to deliberately file the forms and file them correctly. The formation certificate must state the name of the partnership, and there are some requirements as to how it can be named, and name the general partners, but not the limited partners. They get to hide behind the liability shield and won't necessarily get named in any of the initial filings. It's not expensive to file, but it's not free, and one has to go through the name registration steps. Once again, you cannot form an LP by accident. Limited partnerships are formed by a filing with the state, which has to be done deliberately. Once the structure is set up, the general partner has general liability, and the LPs, as I mentioned previously, have a limited liability. They cannot lose more than the amount that they have invested. There's a nifty little trick. Sometimes instead of the GP being a natural person, the general partner can be a corporation, and that provides a block to liability, the corporation being a limited liability entity itself. So while the GP corporation has unlimited liability, the shareholder of that corporation, usually an individual who does the management, does not have any personal liability. So by having a two-step process, we can get around the general liability problem of the limited partnership rather. And this is useful, but it turns out to be outdated, as we'll see in a few lectures, because the limited liability company allows the same result without the blocker corporation. So to reiterate, limited partners have no liability. There are some states that say that if a limited partner engages in the management of the business, that limited partner becomes effectively a general partner. That was true under the older versions like OLPA 1916. The newer versions like RE-ROLPA 2001 no longer have that rule, so even if a limited partner were to engage in some control activity, they would enjoy limited partnership. So the control rule, as it's called, does not pertain to the more modern RE-ROLPA 2001, but it does to the older states that have OLPA 1916 or 1985. In any event, two key things then to note about liability. One is that LPs generally have limited liability unless they participate in control, in which case the control rule applies if we're in a older jurisdiction. And second, that the general partners have unlimited liability, but they can avoid this by creating a blocker corporation, which in effect absorbs the liability from the person. In a limited partnership, the LPs cannot participate in management. As mentioned previously, there's something called the control rule from 1985 and previous. If a LP is active in the management of the partnership, the LP may forfeit limited liability, may become effectively a general partner. That's no longer true in states like Pennsylvania that have adopted the RE-ROLPA of 2001. But in general, the purpose of the structure is to have the general partner make the management decisions. So in general, LPs do not participate in management, although technically they could under newer jurisdictions. The profits and losses are going to be according to the contributions made. So an LP that makes a small contribution will not automatically receive a large share, but rather would receive a pro rata share. Once again, LPs can't be formed by accident. They have to be formed with a filing. Usually they're formed by attorneys who have thought to put a partnership agreement together, and the financial rights should be dictated by that partnership agreement. So we're going to look to that partnership agreement to understand how these limited partners, are going to get paid. The LP agreement must specify an end date, and that's partly because these are funds. These are vehicles that are meant to have a return on investment at some point in the future. They're not meant to go on forever. Under the old versions of the statute, the ROLPA and from 1985 and previous, sort of like the old general partnership rules, withdrawal of any general partner would lead to dissolution, going with the aggregate theory. Under more modern statutes, one would actually have all the general partners withdraw in order for there to be a dissolution of the LP. So it's more of an entity type theory that, of course, is some of our more modern understandings of continuity and nature of business organizations. But again, key point that the LP agreement must include an end date, and in part that's because we're looking generally at funds. Those who invest in funds want to know their money is going to be returned at some point, so they're looking for that end date as well. Control rights, like a general partnership, are generally not transferable in a limited partnership without the consent of the partnership, so the GP can't simply abdicate his responsibilities and give them to someone else. Financial rights generally are transferable, so if you have a stream of cash coming into you from your investment in an LP, you can transfer the rights to that cash, but will have much more difficult time getting control over the LP. And again, limited partners rarely have control anyway, so this is probably not much of an issue, except with regard to the general partner, who does have a great deal of control over the management and cannot simply pass that along to somebody else without the consent of all the partners. And finally, mergers are relatively straightforward. Like the fact that LPs need a filing to begin, they need a filing to merge. Mergers require consent of all the partners, including the limited partners, so that's a relatively high threshold to obtain a merger. That shows that these aren't really meant to be operating companies. They're not really meant to merge. That's not their purpose. Once again, the purpose of these LPs tends to be for fund formation and for a general partner who's going to manage an investment fund and limited partners who will invest passively. That's the general goal, and so we see the rules are created accordingly. Up next, we're going to talk about the corporate form and go over 7 issues that come up in determining whether or not to form a corporation as your business entity.